Judge Hussain? We can
Okay,
start.
we can start. All right. Okay, good afternoon, everyone, and welcome to this course on litigation strategy. Well, let me orientate you first into what you can expect over the next 2 days. Um, the strategy is all about efficiency. You know, I started teaching lawyers about 30 years ago. And back then, we told attorneys and advocates that the purpose of litigation is to win. Now, of course, we all like to win cases, but the world has changed. How we litigate has changed. What modern day litigation looks like is very different to what it looked like 20 years ago. When I said to colleagues, you litigate to win, that came from an adversarial background. I was in I spent my whole life, professional life, in litigation, one form or the other. And litigation, in whatever form, used to be characterized by an adversarial approach. You know, as one lawyer, you want to donor the other side. You want to get a cost order. You want to win. Well, winning is one thing. How you go about winning is another. The new way of describing litigation. I mean, why do we go to court? Oh, it's easy to say, well, we go to court to win cases. But we know, as lawyers, you can't win every case you take to court. You lose some, but the real purpose of going to court, and this has now become foremost in the minds of judges. Going to court is something you do as lawyers in order to assist your client in resolving a dispute. So the purpose of litigation is to resolve the dispute. And that's what this course is about. How do you resolve a dispute efficiently? What are the strategies you should use? And what is the mindset? Now, I can tell you immediately, those of you who want to succeed in litigation, whether you're in a big firm or on your own, doesn't matter. How you litigate, how you deal with your client, how you deal with your opponent, and how you deal with the judge matters. That's where your strategy is. You want a good outcome. A good outcome is not necessarily an outright win with a cost order. That's very nice if you can do that, but mostly you hardly ever get there. The worst outcome, of course, is to lose a case and pick up a cost order against your client. But these days, there is an even more dangerous outcome. It's that case where you lose the case and the judge makes you, the lawyer, pay the costs. A de bonis proprius cost order. Now, that's every lawyer's nightmare. Well, the reality now, as I will show you, is that whereas in the past, judges rarely, if ever, granted personal cost orders against attorneys and advocates. Well, that has changed, and we will deal with that. This course is nothing close to what you did in LLB. This is a practitioner's course. I'm going to present you with method and strategies which work. They work in practice. Okay. Now remember, the legal profession currently is under enormous pressure, as are many other professions. They're under pressure from technology and the internet. Attorneys and advocates now have to compete directly with the internet. It just got a lot more onerous for lawyers with the advent of artificial intelligence. Now, Microsoft's OpenAI is available. There's Chat GPT. There are others such as Bing and Bard, and even X has come up with its own open AI program. This has become quite disruptive. If you go and talk to a doctor now, go talk to your GP, you'll immediately complain and say, you know what? Patients are going on to chat, they are diagnosing themselves, getting the medicine, and treating themselves. And that can be dangerous, but many people will also tell you that it works. Well, what about the lawyers? We are under constant threat from chat. For example, a businessman wants a lease agreement for an industrial site. Well, you go to chat, it will produce one in a couple of seconds. Okay? Whether they know how to use it or not doesn't matter. They've got the document. Why pay an attorney? Well, let's get to litigation, what this course is about. Currently in this country, the open AI resources have not had a big impact on litigation. I mean, we are a bit backward here. You can't compare us to, say, the European Union or the UK or the United States or Canada, and simply because they have electricity. You know, right now I'm speaking to you, I have no electricity. So I don't know how on earth you can talk about AI and the algorithms they use if you can't switch on your computer. So, that's a problem. But generally, when clients get involved in a dispute, they are unable to resolve it by consulting an AI program. They need a lawyer to apply his or her mind to the problem and come up with a solution. Now, having said that, you shouldn't be too comfortable with the thought that AI is not going to affect us as litigation lawyers. Well, let me leave you with one simple fact. Most of you are familiar with online trading, online platforms where you trade, where you can sell and buy goods. eBay is a good example. Amazon is another one. You've got local ones like Take-A-Lot and Loot and so forth. Now, if you take eBay in the United States, it is massive. I mean, millions of transactions a day. And you can imagine when people start buying and selling, there's bound to be disputes. How did they deal with the dispute? They wrote programs which are designed to use algorithms and solve problems that customers have. So if there's a dispute, the person using eBay, whether as a seller or a buyer, gets referred to a website where you present your case digitally. The other side presents their case, and it's done in a certain format. The system begins to recognize words and phrases and starts working out what the issue is and comes up with a solution. Now, here's the bad news. A few years back, eBay alone had something like 2.5 million disputes in the United States. And those disputes were resolved digitally without the need for lawyers. So the point I'm making is it's possible that AI could step up and start handling dispute resolution. So, so getting comfortable is not the answer. So what is the answer? It's a good old-fashioned solution. Make happy clients. When clients are happy with your service, they tell other people. Believe me, the legal profession is still word of mouth profession. You can advertise. When I was a young attorney, we were not allowed to advertise. The Law Society was very fussy about it. Well, everything's open now. You hear advertisements on the radio. You watch attorneys advertising on television and so on. But that doesn't help. What helps your practice to grow is to make happy clients. And how do you have happy clients in litigation? Well, let's start off by looking at some of the big problems. The problem with litigation, as anyone will tell you, and it's not a new problem, it's been an old problem. It takes too long and it costs too much money. That's the problem. And we know from studies that were carried out around the world that the sole cause of matters taking too long and costing too much money are the attorneys, the lawyers. They are the ones who make this problem. If you talk to a lawyer and say, you complain, it takes too long and it costs too much money, it's not accessible to my clients. And yet, when you look at how this attorney runs his practice or advocate, you will see that mostly the long time that it takes, the unnecessary complexity, and the high costs are all created by the lawyers. Lawyers will tell you this is caused by, well, they'll blame the registrar's office. Well, we all know the registrar's office is chaotic, but it doesn't cause the costs to go up. The delays are not caused by the court systems. They're caused by the lawyers. You can test it. Go to the trial court, day one of any trial. There's a very good chance that it will be postponed. And why did it get postponed? But nothing to do with the client. It's because the lawyers were not ready. They did not do their jobs. Now imagine if it took you 2 years to get a trial date, you then get to the trial court, it's in the 3rd year now, and then you have to postpone it. You're going to wait another 2 years to get it back on the roll. We have a situation where cases can take up to 6 years from issue of process to finality, up to 6 years. That's unacceptable. It's completely unacceptable, and it undermines the entire process of dispute resolution. So something had to happen. And a number of things that happened which will impact on your strategies. And that's what this course is about. So what is the modern standard? What do people want? What does business want when it comes to dispute resolution? Now, all of you have come across ADR, Alternative Dispute Resolution. In this country, it's had a devastating effect on the common law. If you go to the High Court, any High Court in this country, the row is dominated by 2 types of cases. The one is RAF. In fact, here in Gauteng, 80% of the row is RAF cases. The other 20% is devoted to various lawsuits against government departments and ministers, like unlawful arrest and medical negligence and so on. What happened to all the other work? The commercial work, banking, insurance. Where did that go? It's all gone to ADR. And the reason the business fled from our courts is because the whole system is too onerous, it takes too long, it costs too much money. In 1999, in England, they were having the same problem. It was taking too long, 6 years to finish a case and costing too much money. So I said, well, how do we address this problem? What is the problem and how can we solve it? And oddly enough, about the same time as the UK decided to investigate this through a commission of inquiry, it was called the Wolf Commission of Inquiry. You can Google it, you'll find it on the internet. It's worth reading. It's quite a long document, but it's worth going through. I will tell you more about it as we go along. The same thing happened in Canada, in the United States, Europe, Australia. They all looked into why on earth does it take so long and cost so much? It's undermining the whole system. And they came up with one answer, all of them. The culprits were the lawyers. So they came up with this thing called case management. You've all heard of it by now. Those of you who practice in Gauteng should be familiar with it. We have case management in our courts. We also have it in the magistrate's court. You will see it in the practice directives. And the whole purpose of case management is not to manage the case. The purpose of case management is to manage the lawyers, is to manage you. Why do you need management? For a number of reasons. Lawyers, how they litigate is part of the problem. From taking instructions to final argument in a trial, it goes wrong every step of the way. And that's what this course is about. We're going to show you how not to make those mistakes. But at the end of the Wolf Commission, by the way, in England and in Canada and the EU, they introduced case management, and they introduced it as long ago as the year 2000. Okay, and here we're still struggling to get it right. 23 years since the Wolf Commission. So the civil standard, the modern 21st century standard, is what Lord Wolf described it as. And it's a classic statement. It says it all. Civil litigation should be avoided where possible. As a lawyer, you are not expected now to take instructions and rush off to court. Should be less adversarial and more cooperative. That's a key element. You are not to be adversarial. You are supposed to cooperate with your opponent, cooperate with the other side, try and resolve as many issues as you can, and only if you absolutely have to, take the matter to trial. But you will take the matter to trial only on a limited issue. It must be less complex. You know, clients don't complicate cases. It's the lawyers who complicate it. It has to be more certain with shorter timescales. Well, that's the whole problem. It takes too long. And when it takes too long, the whole process is riven with uncertainty. So, all of you had this experience. What happens when a client comes to you and says, well, I have this problem. I want you to issue a summons against Mr. X. And you say, sure, we'll issue a summons. Client will say, How long do you think it will take? What's your answer? You look up into the ceiling, you might whistle, and then you look at client, and then you say, well, it depends. And you give him a whole series of depends. And in the end, client walks out not having a bloody clue what's going on. Well, that must stop. It must become more affordable, predictable, and proportionate. The trouble with the system currently is that if you've got the money, you can litigate on a grand scale. I mean, you want to sue someone for barely the jurisdiction amount in the High Court on a simple delictual action. But now, a litigant who can afford it and who wants to show the other side a point starts becoming adversarial. They will get a team of attorneys, get a silk and two juniors, and they'll go to court. And we got away with that in the past. Well, you won't anymore. Judges are very, very sensitive to this. If you are guilty of any abuse, they will let you know. So that's the standard by which we litigate. Now, what are the game changers? The first is post the Wolf Commission report. We had the introduction of case management. We have judicial case management, and this takes various forms, and we will discuss this as we go along. You know that in Gauteng and some of the other high courts, we now have a system of certification before you can be given a trial date. We, for example, in Gauteng, which is the busiest court in the country, the two divisions here, we set down around 125 cases a day, every day, on the roll. That's how many cases there are there. But because they are poorly managed, they're on the roll, trial roll. But out of 125 cases, maybe 2 will need a court, or 3 on a busy day. What happens to the rest? They get postponed, struck off the roll, maybe settled. In other words, they were not ready to proceed to trial. We've reinvented what it means by being trial ready. And please remember this, it's going to be the same everywhere. Trial ready means you are prepared to go to court. At 10 o'clock, the judge walks in and you make your opening statement and you call your first witness. That's what it means. It doesn't mean you must stand down, ask his lordship for an indulgence. Can we stand over till tea time? All that means is that you are not ready. The judge will strike it off the roll. Or in Gauteng, what they do, if you say to a judge, can we adjourn until after tea? The judge will say, very well, we'll adjourn, but I'm sending you back to roll call. You've lost your place. I'll take on another matter. That's one of case management has made an enormous change. Then we have this invention, which they've had for the past 20 years in other Commonwealth countries, court-annexed ADR. ADR is nothing new, but what is new is that ADR is now in our court system. So a judge can say, hold on, I don't have to hear this issue. We can send it to a mediator. It'll be cheaper, quicker. And we will deal with it in some detail. We have a now a relatively new rule, Rule 41A, which is very much a part of court-annexed ADR. By the way, we also have it in the magistrate's court. the Law Society then trained a whole lot of lawyers to sit on these panels of mediators, but it never got off the ground. And the reason is always the same. They don't have the funds to implement. Well, all of you know what happened to the funds. And then there's a third aspect which should concern you, and I'll say a lot more about this. When I was practicing as a young attorney and then as a young counsel, it was unheard of for judges and magistrates to impose punitive cost orders on the attorneys and advocates. Personal cost orders. Well, that has changed. Oh boy, has it changed. I've recently come across a number of cases where the judge disallowed the costs, ordered the parties not to mark a fee, and made an order that if any fees were paid, they had to be paid back. And worse, in some cases, the lawyers were ordered to pay the costs. That is a game changer. And I would add a fourth one here that's also changed things drastically for litigating lawyers, and that is the advent of contingency litigation. For many years in this country, the Law Society outlawed contingency litigation. Of course, it went on behind everyone's backs, and we all pretended it didn't happen. But eventually, it was legalized. What that means is that client can come to you and say, I want you to take this case, but you are going to take it on a success fee basis or a contingency basis. What that means is that the lawyers now have to fund the litigation, and they only get paid not only if they succeed, but if they get the defendant, they succeed in getting the defendant to pay. Until that happens, the firm gets nothing. That has been a game changer, okay? It has opened up more access to the profession. People with good claims now don't have to put down a deposit, which they don't have, and so on. A law firm will take it on a contingency. So it's a good thing, but it also means one other thing, and that is the risk in the litigation is no longer with the attorney. The risk is the risk is no longer with the client. It is with the attorney. Client has no risk now. The worst thing can happen to client is that, they won't succeed. We lost the case. Big deal. They'll walk away. But the attorney may well be sitting with a cost order, which they have to pay. Not to mention funding the case up to the point of trial and not receiving a single cent towards disbursements. Everything has to be covered by the firm. So that's been a huge game changer for litigation lawyers. So if you go to the uniform rules, you will see Rule 37.9a. Oddly enough, this is not a new rule. It's been there for decades. But judges never used it. I mean, I sat on the bench for many years. I can tell you, I never once used this rule, even where I was thoroughly annoyed with the way the lawyers handled the matter. 37.9a says that if an attorney stands in the way of reasonably concluding the matter, the attorney will pay the costs. It's in the uniform rules. The difference now is that judges are using it. And now I want to deal with this. This has become the latest buzzword in litigation, the hopeless case. You see, there was a time when you could litigate, or your client could litigate, just because they can. The courts were there. The courts didn't charge. Back in the day, you put a revenue stamp on your summons. We don't even have that now. The cost is with the cost of the attorney. And if you are on a contingency, the client doesn't pay anything. Okay. But now the courts are saying, and by the way, this started with the Wolf Commission. The Wolf Commission noticed that the lawyers, both barristers and solicitors, come to court with a case that's got no merit. Now, the reasoning is, if these are competent lawyers, then they must know that their case has no merit. And if that is the case, and they come to court with it, that amounts to an abuse. And to deal with that abuse, they don't punish the client, they punish the lawyers. You know, all of us had this excuse. You know, when a judge says to you in court, listen, Mr. Jones, do you really expect me to accept that? Some judges are more robust and they'll say, Mr. Jones, that's nonsense. Well, what do you think Mr. Jones did? We all had the same stock answer. Well, my lord, those were my instructions. As the court pleases, and you sit down. We got away with it. Now the judges will say, hold on, if those were your instructions, were you not able to work out that it has no merits? Why did you bring it to court? You can't come to court and waste scarce resources, taxpayers' money, on a rubbish case just because you can. The judge will disallow your fees and even come up with a punitive cost order. Very recently, there was a decision, oddly enough, in the labor court. And I would like you to go and read this judgment. It's a case of University of South Africa versus Sotiwa. You've got the reference in your manuals, but the judge quoted from an American judgment. And it says this, and this is very important. Make sure this sticks in your head, because if you dare do this, you are going to be out of pocket, and there may even be disciplinary proceedings against you in the LPC, Legal Practice Council. It's the last thing you want. Where a hopeless case is brought with the assistance of the advocate must either be bringing it in the knowledge that it is hopeless, and therefore assisting in an abuse, or believing that it is not hopeless, and therefore incompetent, or not caring whether it is hopeless, and therefore guilty of reckless or gross negligence. In any of these cases, the conduct of the advocate warrants action being taken by the court. And it's actually in an article by Webb. It's called The Hopeless Case. Now, Owen Rogers, Judge Owen Rogers, he's now a judge in the SCA. He wrote an article called, it's on the hopeless case. You will see a whole paragraph in my book called Trial Advocacy, The Art of Persuasion. It's a very important case, this one, for you. What happened in this case is that UNISA launched an application which was completely devoid of any merit. It was just rubbish. The judge in the labor court spotted this. The counsel and attorneys couldn't explain why they didn't realize they were coming to court with a hopeless case and wasting resources. What happened there is that the judge adopted this statement that I just read to you and punished the lawyers. This is the case where the judge said to the attorneys and advocates, you are not to charge a fee. And if you did charge a fee, you are to pay it back within so many days. If you got paid a fee, that is. So, but this is not the only case where judges have punished the lawyers. I'll take you to other cases where this has happened. So be very careful. Now, as a practitioner, before you go to court, there are a number of basic things you have to do. And that's what we're going to deal with in this webinar. You know, there's just something you must understand. Litigation is really at the pinnacle of legal practice. The attorneys and advocates who appear in court and fight their cases, they enjoy a status above anyone else. You know, a commercial lawyer sitting and drafting contracts and doing mergers and so on, they make a lot of money. But who cares? Okay? Then the real face of the legal profession are the litigators. Have you ever come across a TV program about drafting contracts in a law firm? No, nobody will watch that. It's the litigators that attract all the attention. And I must tell you, it can be highly rewarding, both financially and personally. But if you get it wrong, it is the worst nightmare that you can find yourself in. So this course is about helping you to get it right. As a litigation lawyer, it's about applying your mind to everything that you do. You think everything through. From the moment client comes in and gives you a mandate, from that point on, you're thinking all the time. There's one disease that has inflicted many of our colleagues. It's called copy and paste. They can conduct litigation all the way to final argument by copying and pasting. They copy and paste statements, they copy and paste pleadings, copy and paste arguments. I promise you, if you are doing that, you are heading for trouble. The trick is to think, apply your mind, use your cognitive skills, apply logic. That's what a good lawyer does. So these are the things that impact on the profession. I've dealt with it already. You have to change the mindset. The way you think about litigation has to change. I'm sure most of you listening to me now are young people, so you do not have the bad habits of your senior colleagues. Adopt a more cooperative view, or rather attitude towards your opponents. Focus on settling the matter, and your main focus always is to settle the dispute quickly and cheaply. If you can achieve that, you will be a very successful lawyer. We no longer get paid irrespective of result. In the good old days, when I went to court in the 80s and the 90s, you went to court, you lost the case, you sent an invoice, you got paid. Contingency litigation has impacted on that. Now, you don't get paid if you won the case. Oh no. You first have to recover the money from the other defendant. If the sheriff comes back with a nulla bona return, there goes your fees and disbursements. And how does this impact on your firm? Contingency litigation has had an enormous impact on law firms. Now, what I want to do is take you to some basic principles that you must understand as a lawyer. This is none of the stuff you will hear at university. Actually, at university, you hear nothing that is of any use anyway. So, Lord Brown Wilkinson is an English law lord. And I was reading a book. It's called How Judges Decide Cases. And it was written by Andrew Goodman, who went around and interviewed some of the most experienced law lords in England, Lord Brown Wilkinson being one of them. And in that interview, this is what the judge said. The first principle of judging is dirty dogs don't win. And you know what? When I read that, I stopped reading. I had to think about that. And in time, the penny dropped. When I thought about all the cases I lost as an advocate, all the cases where I dismissed a party, it invariably turned out that that party was the dirty dog. Now, what does that mean? It's related to the idea that lawyers should never go to court with poor merits. Now, how do you know, as a lawyer, that your client's case has poor merits and I really shouldn't take this to court? There's one method that works every time. Firstly, as a litigating lawyer, you never start anywhere, not even writing a letter of demand, until you have all the available facts. You never rush off to write a letter of demand and then use a precedent to prepare the particulars of claim. You send it off, the defendant files a bare denial, and now pleadings have closed. I mean, that's how lawyers were litigating here for years. And of course, it irritates judges. Can you imagine? Judges read the papers before they come into court. So they read summons, and they can see this whole thing came out of Ambler or some other office precedent, because the judges have read this many, many times. Then they turn to the plea. What do you see? Bare denials. So the judge is there thinking, it doesn't look like the plaintiff has a case. And what about the defendant? It's bare denial. Well, why should he do anything more if he can't work out what the plaintiff's claim is? So the bare denial might suffice. When you get the facts, the first thing you do is you ask a simple question. Is the version that my client is giving me, is that version likely to have happened? In other words, is it probable? If the answer to that is no, you can't go to court. You will lose. Take it from me, no one wins the case where the version is rubbish, where it's improbable. Some of you might remember that the standard of proof in a civil case is proof on a balance of probabilities. When your version is improbable, then tell your client it's improbable, tell your client why it's improbable, and why it is dangerous to take this to court. Now, often clients, especially the plaintiff clients, are belligerent, they want to sue, and so on. How you deal with it as an attorney now kicks in. You get those attorneys who are even more aggressive and adversarial than their clients. They'll tell the client, oh, don't worry, we'll get the summons to him by this afternoon. We'll take him to the cleaners. We'll get a cost order. And client thinks, wow, I've got a hot attorney. The attorney doesn't know all the facts. He has some superficial knowledge of what the case is about. As soon as client leaves, uh, he prepares summons already. How? From a precedent. Does he plead any of the material facts? No. From that point on, the case is in trouble. You are heading towards losing the case. If your client gives you a story that you don't believe, or if you do not believe that is likely to have happened, your client's the dirty dog. And trust me, if you now represent the dirty dog in court, the judge will make you the dirty dog. So be warned. We'll say more about the probabilities as we go along. But as a lawyer, you don't need to know what the truth is, because that's not the test in our courts. It's on a balance of probabilities. It's not on a balance of truth. So judges know that neither the judge nor the lawyer was at the scene or was present when the incident took place. They were not there. So they don't know what the truth is. They have to rely on the parties to tell them what happened. One way that the one thing judges and lawyers can do is listen to the version and work out, is this probable? The test is not, is this true? Because that test doesn't work. What you need is to satisfy yourself with reference to the undisputed facts what is likely to have happened. And if your client's version is likely to have happened, you're good to go. You can go to court. The second principle, facts are the most important, not the law. As a practicing lawyer, get the facts first. No use running off to the law if you haven't mastered the facts. And I'm being quite blunt about it. It is a stupid lawyer who runs off to read the law, textbooks, cases, and so on, and in this country, more likely to be a precedent, without knowing the facts. That is genuinely a stupid lawyer, and you'll just get into trouble. As a good lawyer, you must know what happened according to your client's version of the facts. Having found that out, you have to now get your client to pass one more test, and that is, if what happened is improbable or not likely to have happened, your client's version will not succeed in court, and your client will be the dirty dog. So that's the second principle. The third principle is related. Never go to court with a version that is improbable or implausible in relation to the circumstances of the case. The standard of proof is on a balance of probabilities. The probabilities must favor your client's version. Then your client can discharge the onus of proof and your client succeeds. If your client's version is improbable in the circumstances, it's not likely to have happened, then you are going to lose. You will never discharge the onus. You will lose. You'll be the dirty dog. Now, those of you who have a keen interest in litigation, I want you to go and read the judgment in NPA versus Oscar Pistorius. You all remember this legless wonder that we had. He murdered his girlfriend. And the trial judge was misdirected by a legal fiction called dolus eventualis. And so the trial judge forgot the most basic thing. and that is to look at his version and ask a simple question: is that likely to have happened? Well, guess what happened in the SCA? There, the judges said, hey, we're not interested in dolus eventualis. Don't tell us about that. Let's look at his version. And they just took it apart. It was, Oscar's version was just downright improbable. I mean, if I told you that my client is a multi-billionaire, fabulously wealthy, he's married to a wife that can only be described as a Barbie doll. So he says to me, for her birthday, I bought her 20 buffalo. Now I ask you, which Barbie doll wife wants 20 buffalo? She wouldn't even want one of them, but he bought her 20 buffalo. It's improbable, but it gets even more improbable. Having bought 20 buffalo, he doesn't take delivery. So the poor wife still doesn't have a birthday present. So, I mean, it is as silly as that. When you go to court with an improbable version, you're a dirty dog, you're going to lose. All I'm saying to you is never litigate on a version that is improbable. And there's a very simple test. You know, when your client tells you a story and you're thinking, I don't believe this. You know, if you're listening to your client and in your mind you're going, this is cock, man. I don't believe it. I'm not suggesting you should stop and say to your client, listen, you're a bloody liar. Don't do that. You can't do that. It's your client. But what you can do is explain to your client why a judge will find this version to be improbable and why, therefore, you shouldn't take this to court unless he's got a better version. This applies equally to motion court practice. If you go to court and you put in a version, and remember, with applications, you have to put in the version and the supporting evidence. So it's more difficult than drafting particulars of claim in an action. So the version that you put in is improbable, not likely to have happened. You're on your way to lose. Similarly, if you're the respondent, your answer to the applicant's claim must be based on a version that is probable, likely to have happened. If not, you're going to lose. I would like those of you who are keen on litigation, go and read the Plascon test. It's a case of Plascon Evans versus Van Riebeck Paints. There you will see a description of the test that judges use to resolve disputes of fact on paper, on affidavit. There you'll see how the version plays a part. Okay, so stop being adversarial, resolve disputes quickly and cheaply. You know, as I told you, I've been a litigator my whole professional life. Not once did I do the following. Client comes in, tells me what the dispute is, and I say, listen, I'm going to phone the other side. I'm going to have coffee with that attorney. We're going to see if we can't sort it out. Never did that. What we did instead was we issued the summons straight away. Get the sheriff, send it to the right now. Okay? And our letters, they were a classic. I mean, you must read letters that attorneys write. Okay? We will address this issue in the appropriate forum. Have you seen that? Attorneys love writing that. What it means is that we actually don't have an answer, but they'll adopt the adversarial approach. We will seek a punitive cost order against you. We will evict you from the premises, and your goods will be will be removed and placed outside on the pavement. We will get a punitive cost order. And of course, my favorite is that after threatening all these horrible things in the letter, the attorney will write the last sentence: we trust the above is in order. Ever come across rubbish like that? Well, it's there. Go and look, check your files. If you can resolve a dispute without starting litigation, that's what you do. You will have a very satisfied client. By the way, the new method, although it's not new anywhere else in the world, but here it's quite new. In matrimonial matters, family law matters, including matters involving custody and access, adverse litigation must be avoided. The parties must be counseled on the benefits of mediation. By the way, I've never dealt with family law as a practitioner. It was a choice. I didn't want to do it, merely because everyone lies, as you know. But I had to deal with them on the bench. And one thing is clear. And even when I dealt with matters involving family law on the odd occasion, the culprits are hardly ever the clients. The adversarial approach where husband and wife are now pitted against each other, it's caused by the attorneys. There's a duty on attorneys and advocates now. We have Section 34 advocates who deal directly with clients. It's their duty to counsel clients in family matters. There's a very good judgment, MB versus NB, you've got it. You see, it's a 2010 case. It was written by an acting judge, Martin Brassey. And there, the parties, husband and wife, they fought each other. The file was enormous. The court file ran into 4 lever arch files. That's how much litigation. When the judge got the papers, he realized that all of this was caused by the attorneys being adversarial. It was not the clients. The clients actually were ready to settle a long time ago. The attorneys were fighting each other. Well, the judge punished them with costs. There's another case, FS versus JJ. That's an SCA decision. Go and have a look at it. Particularly with family law, if you go and get adversarial, a judge sees it, and you know where the judge will see it. The judge will see it in the correspondence. The judge will see it in the affidavits, in the pleadings, in the pretrial conferences. When the judge sees this unnecessary adversarialism in a family law matter, you're in trouble. Just be careful. Onus is very important in any litigation. The proof is on a balance of probabilities. What does this mean? We'll deal with it. How do you apply or discharge the onus in a trial? Let me say one thing before we go any further. I'm repeating this for your benefit. You can never discharge the onus, be it on the plaintiff or defendant. It's usually on the plaintiff. Plaintiff will never discharge the onus on a balance of probabilities if the version relied on by the plaintiff was not likely to have happened. It's improbable. That is what is meant by balancing the probabilities. Judges don't look to the truth because they'll never know. But judges know, lawyers know how to work out if a version is likely to have happened. Okay. Now let's move on to the strategy part of this thing. I'll give you a comfort break at 2:30. Your strategy as a litigating lawyer involves 4 distinct parts. The first part is taking instructions. Now, we all know, we all talk about taking instructions, and those are my instructions. In your letters, you will start by saying, our instructions are. What it actually means is you obtaining all the relevant facts available. That's what instructions are. Secondly, when you've got the facts, and only after you obtained all the facts, your job is to formulate a cause of action if you're for the plaintiff, or a plea if you are acting for the defendant. You must plead correctly and persuasively. But most importantly, under the new dispensation, your particulars of claim and your plea must be based on the peculiar facts of your case. What judges don't want to see is precedent-based pleadings, because it tells them nothing. It's like an accident. Everyone writes the same thing. He failed to keep a proper lookout. Now, what the hell does that mean? Nobody knows. He failed to apply his brakes timeously or at all. What the hell is that? Why lawyers don't plead the actual facts, I have no idea. It somehow feel that if they plead vaguely, then it gives them more options in the trial. Well, I can tell you, nothing is further from the truth. Plead the peculiar facts of your case. By the way, one thing that case management changed is that in the past, your pleadings came under scrutiny maybe 3 years down the road when you're at trial. Now, your pleadings can come under scrutiny within 1 month, because once pleadings closes, a judge can case manage the matter and call you to chambers and say, listen, I've read your particulars of claim. It's obviously from Ambler. I don't know what happened. You're going to have to amend it. If you can't amend it, I'm going to strike it. Defendant, by the way, you pleaded a whole lot of bare denials. Do you have a defense? Tell me, what is your defense and why didn't you plead it? I'll give you 7 days to amend. That's what's going to happen. So you must go back to the first stage and get all the facts first. And of course, once you've got all the facts, smart lawyer will sit down and say and think, is this likely to have happened? Or are there aspects of this version that I, as a lawyer, find to be improbable? I'll need further instructions. Okay. Then the third stage is what we call pre-trial procedures. Things like discovery, experts, attending case conferences, judicial case management, and so on. That's the third part. And the fourth part is the trial itself. I'll take you through each of the 4 parts, and please note that every one of these parts is equally important. You mess up one, it impacts on the next. If you plead a cause of action badly, you'll waste a lot of money in the third stage doing pre-trial proceedings, because you are going to fail in the trial anyway. Okay. Now, I need to deal with this right at the beginning. Practice directives. We never heard of these things in the past. They are now very much a part of our lives, our practices as lawyers. What are practice directives? Well, those of you who have read the uniform rules or used as you use the uniform rules, one thing that will strike you immediately, and that is just how outdated it is. Our uniform rules are outdated. Now and again, they come up. The rules board basically is a part-time board. They are charged with developing the rules and bringing in new rules. They're a part-time organization, and the people who serve there are generally busy in their own right, and very little time is devoted to this. So what happened is that the uniform rules have lagged to the point where they're not very helpful to the administration in our courts. That's where practice directives come in. These are directives that are issued by the judge president or the deputy judge president. And the biggest problem with directives is that they are not uniform. Directives apply only in that court and nowhere else. For example, the directives issued in Pretoria apply only in the Gauteng Provincial Division. It does not apply in the local division in Johannesburg. Johannesburg has its own set of directives. So what are directives? These are directives issued by the judge president directing practitioners. It's directed at practitioners, remember, practitioners to bring their matters to court after complying with certain procedures and requirements. The whole idea is to make, to resolve matters more efficiently, more faster, and more cheaply. So the point to be made is that before you start litigation, whether it's an action or an application, please read or consult the practice directives. It's not enough to know the uniform rules. By the way, the directives do not replace the uniform rules. The uniform rules are still there and they're still valid. You still have to comply. But look at the practice directives. They will show you a different way of complying with the uniform rules. In most of our courts now, with some exceptions, the quieter courts like Eastern Cape and Northern Cape, where the Northwest, those courts are fairly quiet. They don't have a big role, a massive role. So they don't really have many directives. They are quite happy to manage their role because the numbers are small. But remember, even those quieter courts will have a few directives. You need to know them. You will have to comply with trial certification procedures. It is no longer the case where pleadings close, you have a pretrial conference, you then apply for a trial date, you file your minutes, and the registrar gives you a date. Now, it's more than that now. You will have to attend case conferences. Now, this is something fairly new to South African lawyers. We were never used to this. Because, in fact, a place like Johannesburg or Pretoria or Durban, and I would say Cape Town as well, you never saw your opponent. You didn't see the attorney from the other firm. You might see them for the first time at a pretrial conference, but even there, the counsel usually dealt with it. You might see them at the trial, at the doors of, in the court. That too was very, very rare. Counsel turned up. So you didn't really meet your colleague on the other side. Look, in the smaller towns, it's different. The attorneys all know each other, and they met each other. They see each other all the time. It's a small town. They drink together every Friday, so they are less adversarial than the big city lawyers. Now you have to get used to the idea of calling and attending case conferences. You'll attend case conferences over and above the Rule 37 pre-trial conference that you will have. It requires more than that. You may have to have more than one pre-trial conference. You may also attend conferences with a judge, judicial case conferences, and you will attend case conferences with your opponent. Then there are directives that you must read and comply with regarding discovery. Discovery was subject to the worst abuse you've ever come across. Many of you have been in the old style discovery, what we call a wide discovery, where the attorney discovered everything that was in the court file. I mean, everything. If the court file was like 4 big lever arch files, well, the bundle became 4 lever arch files, most of which is irrelevant. Our courts have changed because we know that you can have 4 lever arch files of documents, run a 3-day trial, and you end up using 2 pages from it. Now, who pays for this? It's 4 lever arch files times 5. One for the lawyers, one for the witness, one for the judge, and 2 other copies, well, up to 5 copies. Now, can you imagine what that costs? So it's an abuse. Now, the directives say narrow discovery. You only discover relevant documentation to prove or disprove an issue at the trial. Relevance means it must assist the judge with an issue. If it does not do that, then don't include it in the bundle. Containment of issues. Now, we all know, we learned at university, that the purpose of pleadings is to define the issues between the parties. I can guarantee you, go to the match court, go to the high court, pull out 10 files, litigation files, they're in actions. Read the pleadings, and now ask yourself, what is this case about? You'll be lucky if you found one file that will actually tell you. The pleadings are terrible. We stop that. We want the pleadings to define the issues properly, but we've gone a step further. In some of our courts, we have practice directives that say the parties must agree on the triable issue and write it down without reference to the pleadings. That somehow causes an enormous amount of consternation among lawyers, because now they have to sit and say, whoa, I need to write down the issue. With case management here in Gauteng, you will have to do that. You have to write it down. Forget the issue, forget about the pleadings. Write the issue down. So if you prepared your pleadings badly, you are going to struggle. And if you struggle, there's a good chance you'll mess up in the trial. And then there's expert witnesses. We case manage experts now. In fact, all the courts in the country now case manage experts, because we know if experts are not properly managed, they take up a lot of court time and they're a huge waste of costs. So now we do things like making it compulsory through the directives for experts to meet and file a joint minute. They must define where they are apart, and if they have to be called to the witness stand, they will be confined to that difference only. So you don't use up a lot of court time with the experts. But under case management, I can tell you, maybe 8 out of 10 cases, it's not necessary to call the expert. What the judge will have is your notice in terms of the rule, I think it's 33 or something, the summary in terms of the rule, the minutes of the joint meeting, and that's all the judge will need. You don't have to call the experts. So that's managed as well. If you don't comply with directives, it results in costly postponements. Okay? And that's where you pick up the punitive cost orders. And let me warn you, the trend now is that if there was non-compliance with the directive due to negligence or neglect on the part of an attorney, if you are responsible for the delay or non-compliance, the judge will order you to pay the costs. Okay, it's not going to be costs and that's it. So client pays or costs in the cause. It's going to be a punitive cost order. Okay, be careful of that. So, as I told you, South African practitioners are highly adversarial. You have to stop that. It was brought about by the adversarial system itself. The world has now moved away from unnecessary adversarialism. Now, just get one thing straight. We are still using the adversarial system. What that means is we still have an independent judge, an independent trier of fact and law. The independent judge can only make a finding based on facts presented by the parties in court. The judge has no scope to go beyond that and make any findings. Whereas an inquisitorial judge investigates the case and is actually concentrating on finding the truth. Our judges are adversarial judges. And look, the adversarial method, the adversarialism, unnecessary adversarialism by lawyers comes from there. So it requires a whole mindset, a change of mindset. This is what underpins case management in our courts. Our courts want the practitioners to actually cooperate with each other. And the courts are now going to manage the practitioners. The idea is to go to court and utilize scarce resources only when it is necessary and where there are no other non-adversarial options left. And one of the things that is caused by unnecessary adversarialism and which wastes a lot of costs and court resources is this thing called interlocutory applications. I mean, those of you who practiced in this province, if you go and look at the unopposed motion court row, it runs into hundreds of cases. It's like we run 5 courts sitting Monday to Friday to deal with the motion work. I mean, that's how much we have. A big portion of that is devoted to interlocutory applications. Things like applications to compel discovery, an application to compel compliance, an application for further and better discovery, an application for particulars, and so on. Well, one thing is clear. Interlocutory applications in themselves never resolve any problems. It doesn't. It just creates more problems. And interlocutory applications are mostly caused by the lawyers not doing the work. For instance, in this province, you have to write a letter to the other side to say, please, can you file your discovery affidavit? It's late. And you've got to give them, I don't know, 3 or 5 days. And then if they don't, then you bring an application, which means notice of motion, founding affidavit, you have to serve it, set it down, get someone to appear, and guess what usually happens? The other side then files the discovery affidavit. Now you go to court and you'd get a cost order. Okay. Then you look at the discovery affidavit, it's now inadequate. Now you write again to say, can you discover the following items? Now they don't. Then you bring another application to court and you go through the whole thing again and again. How do you fix this? Simple. Your opponent doesn't file a discovery affidavit. Fine, send him the letter, make a phone call to say, hey, listen, file this thing. Well, if he still doesn't agree, there's a cheaper option. You can go to the case managing judge and call for a case conference. On the agenda, you put there that the other side have not filed a discovery affidavit. The judge will make an order in chambers. You don't have to go to the motion court with it. Case management tries to avoid interlocutory applications. And if you're a good practitioner, you'll try and avoid them too, because all they do is waste costs. That's all. Now, in high courts around the world, we are discouraging needless adversarialism. The statement from Lord Wolfe: where settlement cannot be reached, then the parties are expected to reach settlement on the issues for trial. You are also expected to apply your mind to ADR. Every now and again, the Rules Board comes up with very good amendments to the Uniform Rules. One such amendment is the amendment to summary judgment. I think it's brilliant. Now you wait till the defendant files a plea. If that reads like nonsense, you apply for summary judgment. Now it's so much more difficult to concoct a story and get leave to defend. It's excellent. Another excellent invention by the Rules Board is Rule 41A. What this has effectively done, it has brought ADR into the High Court. So it's now part of the court processes. One of the things about ADR in the past is that it didn't work because it was based on consensus. Both the parties had to agree to, say, mediation or arbitration, and then you went into those processes. If one of the parties is busy delaying the matter, we'll say, no, I'm not going to a mediator, I'll see you in court. And that ended the whole thing. Now it's different. Settlement and mediation must become part of your litigation strategy. So that's part of your litigation strategy. The strategy is not solely to win the case or to win the trial. Rule 41A is in our uniform rules, and the first point I make is that you have to actually comply with it. Not merely comply with it, like creating a form and sending it to your opponent to sign. That's what we did with the pre-trial minutes. You have to actually comply. You have to give written reasons, as I will show you. Practitioners are expected to cooperate and resolve disputes quickly, cheaply, in the best interest of the client. Our courts will punish practitioners. Rule 37(9)A is actually aimed at this, where attorneys refuse to cooperate. You all come across attorneys, you can't get them to do anything. They never take your phone call. They never respond to an email. You leave many messages that go ignored. Notices get ignored. Well, it used to be very frustrating. Now you've got an answer. Write to the judge president, ask the judge president to appoint a judicial case manager. In that letter, you'll give reasons why you need a case manager. we've got an attorney who doesn't cooperate and the matter is not moving. And it won't make any sense to continue to keep bringing interlocutory applications. Okay, Betty, I want to take the break. I see a hand up. There's a question. Do you see that? Betty,
Just give me a second. I'm here.
Okay. All right. Will you take care of the question?
I will take care of it, sir.
Okay. We'll take a 15-minute break. I'll carry on at 1:45. All right, let's get started. You will see I mentioned that practitioners now are expected to cooperate with each other to resolve disputes, and our courts are beginning to punish the practitioners already for taking an adversarial approach. And that's the case of MB versus NB. It was a matrimonial dispute where the attorneys just ran up an enormous bill for litigation. The parties were left with no estate by the time the attorneys finished, and it was all unnecessary. So the court disallowed the attorneys' fees and costs. Before I move on to 41A, there's a question about Durban. How does one go about applying for a judicial case manager in Durban? Look, I haven't looked at the Durban directives recently. My advice to you is first look at the directives in Durban. But even if they don't have any directives around it, the way to go about it is to write a letter of motivation. That's what it's called, a letter of motivation. You can put it in your heading, where you write to the judge president, if you are in Pietermaritzburg, deputy judge president in Durban, where you request the appointment of a judicial case manager. In that letter, you have to motivate why you require a case manager. And mostly it happens because the attorney on the other side is not cooperating or adopting a highly adversarial, an adversarial approach, which doesn't help and is not advancing the matter. I can give you an example of what happened in Pretoria, where an attorney litigated a simple matter. The plaintiff was a bank, defendant was a client who had not paid up his overdraft. So it was simple money's lent in advance thing. But this attorney was an absolute champion of delaying tactics. And he spread this thing over 3 years and the matter was going nowhere. The deputy judge president there got the matter and decided to manage it himself. The first thing the judge did, he noticed that this file was so huge and it was full of these adversarial tricks that the attorney dreamed up and kept the matter rolling without actually going anywhere. So that the judge wrote a letter to the attorney to say, you will attend a case conference, gave the time and date, and then said, you must address me on why you should not be ordered to pay the costs of this matter over the past 3 years. The attorney, of course, thought he was very clever. He did what you can anticipate he did. He withdrew as attorney of record. The judge president then wrote another letter to say, I note you've withdrawn. You still have to attend the conference at my chambers, and you still have to explain why you shouldn't pay the costs. And the matter got settled very quickly. In Durban, I suggest you do that. Write a letter of motivation. I am aware that case management does happen in Durban, but I must confess I haven't read their directives recently. There will also be directives in Pietermaritzburg will be different to the Durban ones. The rest of the question is that what kind of matters can you deal with? Does it refer across the board? All interlocutory matters can be dealt with by a case managing judge. And a case managing judge, in other words, a judge sitting in judicial case management, retains all their powers and functions as judges. So they can deal with a matter, for example, to strike out a defense in chambers, and they can make such an order. Okay. So it's a very useful thing to use. The trouble is the practitioners don't do it. I'm not sure why. Here in Johannesburg, we even have a special court. It's called a commercial court, where if you took a matter to that court, it is automatically handed over to a judge to manage the case. So a judicial case manager is appointed immediately, automatically. In other cases, you apply for an appointment through a letter of motivation. And by the way, if you do use such a letter, you must first serve it on your opponent, get an acknowledgement of receipt, and only then do you send the letter with proof of service to the judge president. And that can work. Okay. So let's move on quickly to 41A itself. And I stress that it is intended to be taken seriously. You have to apply your mind to it, and you have to provide evidence in writing that you did. So actual compliance is a requirement. 41A defines a dispute as the subject matter of litigation between parties or an aspect thereof. So it's very wide. 41A covers just about everything: an action, an application, interlocutory applications, and so on. It's a very wide definition. However, there are certain disputes where judges will firmly focus on and will insist on compliance with this rule. The best example is family law disputes. It is universally accepted that family disputes should never be fought in an open adversarial court. In other words, family disputes do not belong in a court. The culprits, of course, are not the clients. It's the adversarial practitioner. And if you ask the adversarial practitioner, why did you do that? You'll get the same famous answer. Those were my instructions, my lord. Well, it doesn't work anymore. The first prize is to settle the whole dispute through mediation. If you can do that, you've done your job. But the rule also requires parties to settle some of the issues, because we know that very often there are genuine disputes of fact and law between parties, and they're unable to settle it, and they require a judge to rule. If mediation can result in narrowing triable issues, then the rule has served its purpose. So your job is to talk to the other side, send a notice in terms of 41A, and talk to the other side to say, look, can we meet and discuss the issues? Can we try and narrow the issues? 41A2 applies to it. The rule applies to every new action or application proceedings. You are required to send a notice to the other side, whether you are plaintiff or defendant, applicant or respondent, calling on them to indicate in writing. This is the trick, whether such party agrees to or opposes the referral of the dispute to mediation. So you can't ignore it, or you can't use a precedent type response. You have to respond in writing. It is recommended that you take instructions at the point when you commence litigation. So part of the strategy is when your client tells you he's got a case, whether as plaintiff or defendant, when you are obtaining all the facts, and please, first obtain all the facts. It's a bad attorney or advocate who discusses settlement and ADR without obtaining and knowing all the relevant facts. So what is intended by this, by the rule, is that when you take instructions, part of that process now is for you to counsel your client on the possibilities of settlement through ADR, and it also includes the possibility of settling the matter without launching any proceedings. Sub 3 facilitates for the mediation process to be introduced or used at any other stage of the litigation. So at any stage before judgments, the parties can refer a matter or a single issue to a mediator. Now, here are some practical suggestions. When you and your opponent agree to mediation, it is absolutely essential for both parties to consider what issue or issues is being referred. You cannot possibly engage in mediation if the parties don't have a common understanding of the issues before the mediator. This must be defined and must be written down. Once you agree on it, write it down. If you agreed on it in a case conference with your opponent, there'll be minutes. This will be recorded in the minutes. You can also seek guidance from a judge or a judicial case manager. Where the matter has already commenced, you have to seek leave of the court for a referral. That will also be a good time to settle or define the issues with input from the judge or case manager. So you've got all these options. Sub 4, where the parties agree to a referral, you're required to do two things. The parties must present a joint signed minute of the agreement to refer, and prior to commencement of mediation, the parties must enter into an agreement to mediate. Most of you are familiar with this thing called an agreement to mediate. Now, just on a practical side, the rule discourages rigid formality, and the parties are expected to sign an agreement to mediate. You may include a definition of the issues and the scope of the mediation in this agreement. What you don't want is for you to use your office precedent for an agreement to mediate where you've got 15 pages of boilerplate clauses and so on. But don't do that. Keep it short, simple, 2-page agreement. That's what the judge wants. Sub 6 is an important provision, and it is designed to encourage mediation. So all documents, oral or written, all communications, oral and written, and documentations used in the mediation is treated as confidential. In the event of continued litigation, it cannot be admitted into evidence. So there's confidentiality. It makes the parties more free to engage one another in settlement. And then there's also the issue of costs. The fees of a mediator will be borne equally by the parties unless the parties agree otherwise. When the court considers an order of costs, when concluding the action or application, the parties may refer the court to the notices in sub-rule 2 and may allow the judge and also draw the judge's attention to offers and tenders. These things are kept secret, but when the matter is finalized, how the parties behave towards one another may become relevant to the issue of costs, and then they can be revealed to the judge. The moral of the story is, again, adopt a conciliatory approach, adopt an approach of cooperation, non-adversarialism, and that is what is intended for this particular rule. In order to encourage parties to refer issues to mediation, the fees charged by mediators are expected to be reasonable. Now, I'll tell you what's going on. Uh, we in this country, although we brought court annexed mediation into our procedure, we do not have panels of mediators. We have, if you look at how the Canadians do this, and in the UK, the court appoints suitably qualified people to serve on panels of mediators. And they are qualified in various disciplines like banking, construction, tax, family law, etc. So they have the necessary skills. And then when a judge says, listen, this matter can go to a mediator, there's someone available. They can consult the names on the panel, pick one of them, and refer to them. Easy. But most importantly, when you have a panel, you can agree a tariff of fees for mediators. Now, that's a problem here. We don't have a tariff of fees for mediators yet. We are going there, I can tell you. You have to be careful about your choice of mediators. See that they will agree to a reasonable fee. If the fee is unacceptable, just move on to another mediator, okay? And if one of the parties says they cannot afford a mediator, then there's a simple solution. Go to the judge and say, look, the parties are ready to mediate, but one of them cannot afford to pay the mediator at the moment. The judge can make a ruling over costs. For instance, the judge can say, well, I'll rule that the costs in the mediation will be costs in the cause. Go and carry out your mediation and proceed. The mediator must be informed of that. Also, the party who can afford to pay the mediator should actually pay, and then they'll recover the costs at a later stage when the costs of the action are being dealt with by the judge. So don't allow costs to get in the way. And by the way, the person who asked that question asked a very good question, because if one of the parties wants to avoid mediation, they want to kick for touch and run the thing for 3 years, they can say, well, I can't afford the mediation. Well, there's a solution to that. Okay? There's a good practical description of how to use 41A. Those of you who use LexisNexis's PG civil procedure will have access to it. I wrote the whole section, so go and read it, okay? So I want to move away from 41A, and I want to go to there's something that most people forget about. The judge. The role of the judge now has become so important because the judge is no longer someone you'll see on day one of the trial. You are very likely to have a judicial case manager if your matter is complex, and very often that the judicial case manager will not be the one who hears the trial, because there's a possible allegation of bias. Suppose the judge may be involved in the matter. So what we do is the parties have a choice. If they're quite happy for the judge who case managed the matter to proceed with the trial, that's fine, done. But if one of the parties has a perception that this judge may be a bit biased, may have made rulings favoring one or the other side, the judge president will allocate another judge. By then, the matter will be confined to a single issue that will go to trial. Now, it is always a good idea to consider what judges do, before you start litigation, ask yourself, what will a judge do with this case? What is the judge looking for? And how am I, as a lawyer, going to persuade the judge to find in my favor? Now, we know that you, as a plaintiff, you will have to persuade the judge to accept your client's version of what happened, to find that it was probable, likely to have happened, and then make a ruling in your favor that you have discharged the onus on a balance of probabilities. Now, you will likely encounter, as I said, judges in two roles, as case managers, and then secondly, as presiding officers. So we'll deal with the strategy with both. So, what are judges looking for? Judges want to be able to read your pleadings and to be able to work out 2 to 3 things. Firstly, what is the plaintiff's version of what actually happened? Secondly, based on the peculiar facts of the plaintiff's version, what exactly is plaintiff's cause of action? And thirdly, based on defendant's version, what is the defense? Now, this sounds simple enough, but as I told you, you can test it. It doesn't matter where in the country you may be. Go and draw files from the court, read the pleadings, and ask these questions. What's the cause of action? What happened according to the plaintiff's version? What is the defense? What happened according to the defendant's version? You won't know. You will not find out because the pleadings come from precedents. When you are stuck on precedents, your pleadings are of no assistance to a judge. Now, just to inform you of what's happening around the world, the developments. If you take the UK and Canada, and I think Australia has done it as well, they've scrapped pleadings. They no longer have particulars of claim. What they have is a statement of claim by the plaintiff coupled with a certificate of truth. They don't have a plea anymore by the defendant. They have a statement of defense coupled with a certificate of truth signed by the defendant. The reason they've scrapped pleadings is that judges have found that pleadings tend to be very technical documents, technical to the point where they don't tell the judge much at all. So having read the pleadings, the judge doesn't know what the case is about. So the judge now relies on the minutes of the pretrial conference. Well, that doesn't tell him much either. So they scrapped the pleadings. We still have pleadings. Those of you who do arbitration work will see that in arbitration, we generally use statements of claim and statements of defense. The reason being that the material fact or the version emerges. Whereas in particulars of claim, it gets too technical. The parties say as little as possible. But the worst thing they do is that they plead from a precedent. Okay. Now, if the pleadings are not clear, the first thing a judge will do, before hearing the first witness, the judge will say, write down the tribal issue and hand it to me. I've read the pleadings, they're unhelpful. I want you, plaintiff and defendant, get together, write down the issue and send that document to me. You'll be amazed at how lawyers struggle with that. I'll tell you why they struggle with it. Because they did not obtain all the facts before embarking on litigation. That's where the fault lies. Judges generally do not encourage parties to bring opposed and unopposed interlocutories. They can now be dealt with in case conferences. You put it on the agenda. Whenever you call a case conference with a judge, whichever party wants to have the conference, that party initiates the conference by first writing to the other side saying, I'm going to call for a case conference. This is the agenda. Please add your items to the agenda and send it back to us. This will then be placed before a judge. So we don't want interlocutories. They take up court time, they clog the roll, they cost a lot of money, and it's for usually achieves nothing. Judicial case management is directed to resolving as many disputes as possible, including disputes of fact. Now, I told you interlocutory disputes can be dealt with there. My experience is that where a judicial case manager is appointed, the parties start behaving. So, if someone's discovery affidavit is late, one phone call, they'll sort it out. Because they know the next step, you'll be in a case conference and you might pick up a cost order. Judges can make cost orders in case conferences. So apply your mind at an early stage to discovery. All judges now will require narrow discovery only. Okay. Now I'll say a little more about discovery later. In particular, I'm going to talk to you about electronic discovery and how you manage that. I just want to mention to you, all of you, it doesn't matter where in the country you are, all the documentation that you will have in things like commercial disputes, contractual disputes, delictual disputes, and even family law matters. The documentation will have as its source a computer. No one types, no one writes. Everything is done on a computer. It could be on a desktop, a tablet, or a telephone. You must understand how to prove the authenticity of those documents. For example, someone produces an invoice as proof of purchase. If you are the defendant, you will get a copy of that invoice. You will then ask the other side to give you access to the metadata. Then you can see if what you've got is what is on the hard drive and it was not tampered with. What's the purpose of this exercise? You will be expected in a case conference or pre-trial conference to make an admission. If you don't admit a document, you must have very good grounds for doing so. In other words, you'll have to go to court and tell the judge you don't admit that document. Here are my reasons, and I expect the plaintiff to prove its authenticity. You better have good reasons, because if it turns out you can't challenge the authenticity of the document and you did not admit it, the judge will nail you with a cost order, promise you. Those games we don't play anymore. Expect a judge at an early stage to expect you to articulate what your versions of the facts are. Whether you plaintiff or defendant, the judge would like to know. Then get ready to make admissions of fact. The judge will actively assist the parties to confine and define the tribal issues. Now, the issue may be a factual issue, or it may be a legal issue, or it may be both. A judge is more likely to intervene where the parties filed vague, precedent-based pleadings, okay? I'm not saying don't use precedents, okay? I don't have a problem with you consulting Ambler or any of the other books that have pleadings. The worst thing you can do is use your office precedent file, which was compiled in 1948 by the senior partner and passed down over the years. To use outdated precedents is a sin, and you should be punished for it. And that's exactly what will happen. Use them responsibly. But in litigation, the precedents should tell you what are the material facts that you require in order to sustain a cause of action. Your job is to plead the material facts based on your client's version or your client's facts. Now it starts making sense. The same if you're a defendant, okay? Remember, in a trial, the judge must first make a finding of fact before applying the law. You must be alive to what findings of fact you want the judge to make. Now, findings of fact depend on, firstly, a set of undisputed facts, which is made up of facts that are not challenged, facts that are admitted by the other side, which were initially challenged, but now they're admitted, documents that don't require proof. So in any trial, a judge will have a set of undisputed facts. Those undisputed facts are very important because they help the judge to do two things: weigh the probabilities, to make a finding of fact. I will deal with this in more detail in a moment. It's very important for you to understand that. And then finally, judges do not hesitate to punish litigants who do not cooperate. In the past, we never did. Now you get nailed. The lawyers are getting stick for being incompetent, for being reckless, for coming to court with cases that lack merit. Rule 37(9)(a) is one of those instruments that judges use. Now, this is important. I want you to concentrate. Judges, as I told you, were not there. So when a witness testifies, the witness is on the stand, the witness takes the oath, and now is led in chief, and then the witness is cross-examined by the other side. The judge has to make findings of fact from the evidence the judge hears. The judge cannot make findings of fact based on something that's outside the courtroom. That is what an inquisitorial judge can do. The judge in an adversarial court has to listen to the witness, has limited scope to ask questions. Judges can't descend into the arena and cross-examine a witness, as some judges are tempted to do. The judge has to listen to the evidence and then evaluate it and decides whether he accepts it or not. So this is how the process works. And I'm taking the trouble to do this because it gives you a better understanding of how to run your trial. But more importantly, I told you, when you've got all the facts, your first job is to ask yourself, is this likely to have happened? If the answer to that is no, well, you have to go back to the drawing board. You certainly cannot start litigation. You'll have to explain to your client why you can't start, because the version he just gave you is not likely to have happened, and that's what a judge might find. So you're at risk of losing with costs. So the process that I'm going to explain now is similar to what you are going to do with your own client in the comfort of your office. First, step one, the judge hears the evidence through witnesses. That's where the evidence comes from, witnesses. There are also other sources of evidence, admissions, documents, visual evidence, and so on. Secondly, the judge evaluates the witness. So, what does the judge say? The judge listens to a witness. The judge makes an assessment of demeanor, the judge hears the version and asks that one important question: is this likely to have happened? The answer is yes. Well, I'll evaluate further. The judge also evaluates relevance. Then the judge will evaluate the performance of the witness. Do I find this witness to be truthful? Is this witness clearly a liar? This witness has contradicted the version and so on. So the judge hears the witness, evaluates the witness. Third step, the judge makes a finding of fact. So what the judge does, the judge hears witness A, evaluates the witness, finds that the witness's version is probable. The judge accepts that version. Once the judge accepts that version, the judge makes a finding of fact based on that version. And the fourth step, once the judge has made findings of fact, the judge now draws inferences from those facts. That is how a judge makes findings in a trial. You do the same thing in your offices, in your chambers. Listen to a witness, evaluate this witness. Is this version probable? Am I convinced this witness is actually telling the truth? Now remember, you won't have the benefit of cross-examining your own witness. Although many law firms, especially the American ones, will put their own client, through cross-examination in a simulated hearing, just to make an evaluation of how they will perform. But you don't have to go that far here. A good lawyer just hears the facts and asks, is this probable? Is this likely to have happened? Will a judge accept this version? If a judge accepts this version, what finding of fact can the judge make from this witness? The judge will then end up with findings of fact which were obtained from various witnesses. The judge will then look at those facts and then draw inferences from those facts. Your job is to persuade the judge to draw inferences that suit your case, inferences that will assist your case and not your opponent's case. This is a very important, this is the logic that judges use. Judges don't sit there and think, well, I need to work out if this is true. How will they know it's true? They were not there. Okay. So just to make this clear, when a judge evaluates a witness, the judge is listening, the judge sees the witness in the box, the judge observes demeanor, the judge listens to the questions and the answers in chief and in cross-examination. The judge does, when a judge says, I accept that version, what the judge is saying, that I find that version to be likely to have happened. It's probable. So for purposes of this hearing, I'll accept it. Then the judge will say, I find witness X to be a truthful person, a truthful witness. I accept the version. It doesn't mean that witness X actually spoke the truth. What the judge is saying, for purposes of this hearing, I am persuaded that the witness told the truth. I'm now going to make findings of fact based on that witness's evidence. Then I'm going to draw inferences from those facts. Okay? That's how it works. You know, again, from Andrew Goodman's book, he said this about judges. A judge engages with real people and real conflict, where invariably he or she is faced with a choice between opposing parties. You'll have versions that are mutually destructive, and has to do the best he can with the evidence available, according to the burden and standard of proof. Now, here we introduce something else. I told you, number one, hear the witness. Number 2, evaluate the witness. Number 3, make a finding of fact. Number 4, draw inferences. Having done that, a judge will ask a simple question. Number 1, who bears the onus of proof? Okay, it's the plaintiff. What's the standard on a balance of probability? If I draw these inferences, will the plaintiff have discharged the onus? The answer is yes, the plaintiff succeeds. If the answer is no, the plaintiff loses. Okay. So it's important to understand this. When you know what a judge is doing, it makes your life easier because you know what you need to do in order to persuade the judge. It is your job to assist the judge to find that your client discharged that burden of proof. Okay? And I'm warning you, it starts with your drafting. Draft good pleadings, draft good affidavits. Then you are on a winning streak. If a judge is not impressed with your pleadings, finds them to be vague, finds them to be precedent-based, that you start on the back foot. When the judge walks in and expects you to make an opening statement, they already have a negative view of your case because they don't know whether you've got a case or not. You were not able to commit it to paper. Your pleadings are rubbish. Okay. A judge's reasoning and conclusion must be practical, suit the facts as found. Remember, a judge's reasoning takes place when the judge starts drawing inferences from the facts as found to be proved and must provide an effective workable remedy to the winner. Many people don't realize judges genuinely want to do justice. That's what they're there for. And many judges are careful that they don't come up with a result that defeats the whole purpose because it can't be executed. A judge cannot make an order which is not practical and capable of being executed through the sheriff. No judge can make such an order. So a judge will be looking at a workable remedy. Now here's the trick. When you go to court, tell the judge up front in the opening statement, this is the remedy I'm looking for. I will show your lordship or ladyship that this is a workable remedy capable of being executed. It will be in the interest of justice. You must tell the judge what is it you're looking for. Good lawyers will prepare a draft order and say to the judge, in opening statement, my lord, may I hand up a draft order? That's what I'm looking for. Okay. I know it sounds a bit presumptuous, but don't worry, judges expect it and they know what to do. A judge cannot be expected to come to a conclusion without first informing herself of the facts and the law. It's the same process I just mentioned. But what I'm trying to say here is that poor facts means poor outcome. What happens when lawyers lose a case? First, they'll blame the witness. You must have heard lawyers say, oh, my witness dropped me. That's the phrase. My witness dropped me. Okay. Or the other very favorite excuse, the judge is an idiot. The judge didn't know what he was doing. The judge got it wrong. When you present a judge with a set of facts that are not comprehensive, that are not relevant, they are not admissible, and they are not probable, if you give the judge that, you will lose, and please don't blame the judge. So before you start, do the following. Okay? Find out what are the material facts of your client's case. Secondly, assume that you can prove those facts. Now ask the next question. What remedy can your client practically obtain? Okay. Now, very often you go to court, it's a claim sounding in money. Easy. You're suing for enforcement of a contract. A defendant didn't pay an amount of 500,000 Rand. Easy to plead, easy to quantify. In a delictual action where you sue for damages, not so easy to quantify because you may have to use an expert. You have to justify how the amount was arrived at. You can't do a thumb suck and plead it like we used to in the good old days. Okay. The remedy that you want must be something your client can practically obtain. Now, my advice to lawyers is that this is something that you must canvass with client right at the beginning. When you take instructions, what is it that you want? Tell me what you want. Or you want payment of 500,000 Rand. Now, let me ask you another question. Can the defendant pay it? Does he have assets? Is he a man of straw? If the defendant can't pay it, is there any point in embarking on expensive litigation? This is a question you have to ask. Because I'll tell you what can happen. You can win your case. And client will be very happy. Oh, we won. Wonderful. Great lawyer. And then you execute and you get the nulla bona return. Client looks at this and say, what does this mean? It means you're not getting paid. Oh my gosh, all hell will break loose. Because the first thing client will say, you didn't tell me this was a possibility. I spent all this money on litigation. If you told me at the beginning, I would not have done it. And now the complaints go off to the Law Society or the LPC and so on. It's just a headache. Discuss what your client can practically get out of the litigation. Discuss it with client, put it in your mandate. And there's a very important comment I make here. For any litigating lawyer, there's only one rule. Obtain the available facts first, okay? Remember, it's facts first. And seeing as there's elections in America again, make facts great again. Okay, those of you who follow that lunatic up there, make facts great again. It's true, okay? So why does it go wrong? Where does it go wrong? Practitioners are too much in a hurry to issue papers. Listen, the only time you rush is when you are facing a time bar. A time bar would be the claim is prescribing, or there's a time bar in the contract, like you would find in insurance contracts. Your client came to you late. You don't want to get involved with applications for condonation. Then you issue summons in a hurry. But when I say in a hurry, I mean you'll work through the night. You're not going to bang out a summons. You must have heard that phrase, bang out a summons. South African attorneys invented that, bang out a summons. If you do that by grabbing a precedent and using it and you issue the summons, just remember one thing. If you are facing a time bar and you got the wrong cause of action, it does not interrupt prescription. Your client's claim will be prescribed anyway, and you may have to go into condonation anyway. So do it right the first time. Lawyers, especially litigation lawyers, have to get used to working long, long hours, okay? This is not a job for lazy people. But if you're not facing a time bar, then for God's sake, take the time, calm your client down. There's no need to rush. I need to get all the facts. You still have to bring me these documents. I need to evaluate your witnesses. Then I'm going to prepare the summons or application, and I'll deliver it to the other side. So if you simply go ahead and rush into it, the judge will not be listening to you. Before you even start, the judge thinks you don't have a case because your pleadings are rubbish. You will not assist the judge. And, I keep telling lawyers, it's all very well to say, I want to win the case. It's about how you go about doing that. You cannot be successful in a courtroom if you are not focused on assisting the judge. That's the focal point. Assist the judge and you will succeed. So what makes judges listen to you? Firstly, the pleadings make sense and disclose a cause of action or a defense. Judge can read it and say, I can see what the case is about. A compelling version of what actually happened. The party's case concept. In other words, what happened according to the plaintiff's version? What happened according to the defendant's version? When you draft pleadings, I always get asked, when have I crossed the line and pleaded too much? You learned at university that you must not plead evidence. Facta probantia. You must only plead the material facts. Facta probanda. Now people are sitting back and saying, now the people are sitting there thinking, well, how much facta probanda do I plead? At what point does it become facta probantia? My advice to you is very simple. Write down your client's version. You're supposed to do that. Write it down sequentially. Now read through it. Write down, make a note of whether or not that amounts to a version that is likely to have happened. Then ask yourself, how relevant is this version to the dispute between the parties? You would have a proper statement that will guide you as to what amounts to facta probanda and what is facta probantia. Because what you do is that you first get the facts down. When you got all the facts, now go look at the law. Never look at the law if you don't know the facts of your case. You will be misdirected. It's a very dangerous thing to do. Get all the facts, now look at the law. And remember, you're not at university. When you look at the law, look at the case law. I recommend that if it's an area of the law you're not too familiar with, read a recent textbook. The recent textbook gives you the principles. And very importantly, the textbook will refer you to case law. Then you go, before you draft anything, go and read the judgments. The judgment that you require, that you will rely on, is the most recent case of the highest court. That's the test. And you only need that one case. You don't need to read 10 more cases. Okay. Those of you who don't know how to use annotated cases, electronic law reports with case annotations, if you don't know how to use that, you are going to be very inefficient. You'll waste a lot of time and your client won't be able to pay for it. So go and learn how to use annotations. When you draft particulars of claim, it's always useful to say, this is the factual background. Write down the material facts that make up your client's version of what happened. I always tell practitioners, err on the safe side. put in more facts. I've not come across a practitioner who got punished for putting in more facts. They get punished for putting too little facts, for being too vague. So if you have a doubt as to whether this should go in or not, put it in. You won't go wrong. But remember, you had already worked out if your client's version is likely to have happened. The version must be consistent and support your client's cause of action or defense. Remember, you are going to draft your cause of action or defense based on that version. I told you, adversarial judge is not a seeker after the truth. The judge was not on the scene and will rely on the parties. The evidence must be relevant to the issues. Okay. Now, what you've got here is a 3-point test. Those of you who attended my previous courses will know you must test the evidence in 3 ways before you call the witness. Number 1, is the evidence relevant to an issue? If the evidence is not relevant, don't test it for anything else. Probabilities, truthfulness, and admissibility, don't test it. Just throw it out. One thing that judges hate, they hate it when you waste their time with evidence that is not going to be of assistance to them. It's not relevant. That's test number 1. Test number 2, it's not enough for evidence to be admissible. It must also be, to be relevant, it must also be admissible in its form. In other words, you're in a courtroom. There are rules of evidence. Your evidence must first be relevant, which is a rule of evidence, by the way. Secondly, admissible in its form. Like it must not be hearsay. It must not be lay opinion or character, things like that. And thirdly, by now you will know this, the version must be probable in relation to the facts of the case. Okay? Relevant, admissible, probable. Your witness passes that test, you call the witness. If your witness fails any one of those, don't call the witness, okay? You will run into trouble. It must be all 3. If your witness passes one of the 3 or 2 of the 3, it's not enough, okay? The defense must also be based on a set of facts which make up the defendant's version. Bare denials don't work, okay? So when you take instructions, you are obtaining the available facts. This is where you obtain the facts. You get them from client statements, statements from witnesses, documentation, and in this I include electronic documents. They're all electronic now. You can just take it. Unless you still got a case that has been hanging around for the last 20 years. It's all going to be electronic. Visual evidence, super important. These are things like photographs of the scene, CCTV camera footage, pictures taken by a drone, recordings that were made, all digital information. For example, the information taken out of the electronic control unit of a vehicle, or the hard drive of your client's computer. Digital information and documentation now, and including your visual evidence, it's all going to be electronic or digitized in some way. You must learn how to obtain them first. Secondly, how to prove their authenticity. Some of you might be familiar with this so-called first state capture case in Free State, the Nulane dairy case, where these people stole 25 million in a scam around a dairy that was supposed to be meant for disadvantaged farmers. The state prosecuted 7 of them and failed terribly because the judge granted a discharge. You know where the problem was? The problem was with the documentation. You see, everyone says, the journalists say it all the time, oh, look, the Zondo Commission gave the NPA all the evidence, and they still can't prosecute. They are useless. What they don't realize is that Zondo was a commission of inquiry. What Zondo was exactly what it says on the tin. It's a commission of inquiry. It's not a court of law. Commissions of inquiry have a habit of playing fast and loose with the rules of evidence. For instance, they would introduce reams of hearsay evidence and then put it together and say, oh, NPA, here, this is for you. Here's all the evidence. Now, a prosecutor getting these files will look at it and say, hold on, this is hearsay. How am I going to prove the authenticity of these documents if the defense object? Now, it doesn't take genius to work out that in a criminal prosecution, the defense will object, and they will not make admissions. So you've got to set about finding the metadata for these documents, accessing it, satisfying yourself that the document you have is a true copy of what was created on the computer. You'll take a photograph of the metadata, or you will download it and you make it available to the defense. So there's a whole process that's involved. As lawyers these days in the 21st century, you must learn how to obtain, preserve, and prove electronic evidence. You must go and read the Electronic Communications and Transactions Act. That's a very important piece of legislation. It's already a bit outdated, not a bit outdated, very outdated. But that's what we've got. And there are a number of cases that you can read on that. Evidence is the key. If your facts are strong and you can present it to a judge, you discharge the onus, you win. And then at an early stage, you have to identify expert witnesses. Now, that shouldn't take genius because the nature of the action will tell you if you will require an expert to either prove the merits of your claim or to assist you with quantum. Now, this applies only to Johannesburg and Pretoria, where I'm not so sure about Pretoria, but I know in Johannesburg there's a directive. When an attorney issues a summons, the attorney must indicate at that point to the registrar whether or not experts will be used. And then the case number will have an E before it, indicating to the judge that this case involves experts. Then they will case manage the experts that will be called. Now, this is not in every court, but it's a very good idea for you as a lawyer to identify, firstly, the need for an expert at an early stage, and secondly, when you've identified the need, go and engage the expert straight away. before you issue the summons, the expert can assist you with your particulars of claim. And it's a good idea to get your expert as early as possible, because in this country, there's a shortage of experts. So if, as a plaintiff, you have an advantage, you can engage your expert, the best one available, and then you can leave the rest to the defendant. So it's an advantage, don't lose it. So how do you go about doing this? Establish that your client's version is likely to happen, bearing in mind the circumstances of the case. A useful test is to ask, do the undisputed facts support my client's version? If it does not, you have a problem. This is a test used by judges to work out whether or not a version is likely to have happened or not. You see, in every dispute that comes to court, factual dispute, there will be a set of undisputed facts between the parties. Judges make a note of all these undisputed facts. That's what you do as a lawyer. Write it down, make a list of the undisputed facts. Now, when you get to the disputed version, ask yourself, do the undisputed facts support your client's version? If the answer is no, you've got a problem. If the answer is yes, you've got a decent version there, you can use it. Just to give you a simple example, you're the plaintiff in an accident. Your client, the plaintiff, tells you that on the day in question, the driver of the other vehicle drove through a red robot, caused a collision. And the client, you ask a simple question, were the robots functioning? In this country, that's the first question you ask, because our robots hardly ever function, unless you're in Cape Town, where they do function. Somehow, Cape Town robots are different. It's always baffled me. So you ask the question, the client says, oh, yeah, they were working fine. Now, that's a version of your client, that when he approached the robots, they were working. The other driver went through a red robot. Now, you then consult the records of the municipality. And there you find that on that particular date and on that time, at that time, the robots were actually not working. So now there's an undisputed fact there which contradicts your client's version. That's very bad. You can't go to court with that. Okay? Establish that you have supporting evidence in the form of reliable witnesses on corroboration and credibility. Now, corroboration and credibility are just two means that judges use to evaluate the witness. In other words, can I accept the version or not? But I can warn you, if the judge finds the version to be improbable in the first place, they reject it straight away. They don't even test it for credibility or look for corroboration. They don't. So you can see how important it is to come to court with a version that is likely to have happened. Make an effort to already take steps to secure the presence of witnesses on trial day. This is something lawyers make a mistake with all the time. In this country, you cannot take it for granted that a witness who told you in your office that they will be there and they will testify, don't ever take it for granted that they'll turn up at the trial. In this country, people disappear without trace. And also, you know that between taxi drivers and aides, they die a lot. You're going to have a problem if they're now deceased. You do two things. When you find a witness that passes the test, in other words, that witness tells you a version that is likely to have happened, you think that witness is credible, you would like to corroborate that witness, You will find corroboration in the form of another witness or a document, a contemporaneous document that was produced at the time. Okay. So when you find a good witness, number one, take down a statement. The statement must be in writing. You must write the statement down. And the statement must be signed by the witness. It doesn't have to be under oath. It's not an affidavit. It must be signed. That signed original must be kept in a safe place. The reason is simple. If that witness disappears or is deceased on the day of the trial, you can use the Law of Evidence Amendment Act, Section 3, to introduce that statement into evidence. Otherwise, it will be excluded as hearsay. So it's important for you to write the statement, have it signed, okay, by the witness. That's the one thing you must do. Number two, take all the contact details, and as the attorney, you should from time to time contact the witness, see if they're still around. If you can't get hold of them, call client and say, I can't find this person, now go look. Okay. So in other words, try and ensure that you can have them in court on trial date. And if unfortunately they died, you will have the statement. Okay. And then this is a very practical, important part. Establish a sequence of events, a chronological sequence in respect of your client and witnesses' version of the facts. Always take down a witness's statement in a chronological sequence. Simple. If the sequence doesn't make sense, then the version is not likely to have happened. It will be improbable. Sequencing is vital. You should arrange all documents sequentially before you review them. It is dangerous. It is a dangerous mistake to review documents, especially in commercial disputes. You know, if you do work for banks or a big retailer or something, or insurance company, always sequence the documents first. Never review them without sequencing them. Now, you know, clients will bring you documents that are not sequenced. They might email documents to you. They will not be sequenced, okay? Your job is to sequence them. And by the way, this is a very useful habit because when you get to trial, you will be required by the judge to present chronology documents, okay, or chronology tables. This is a one-pager that tells the judge in a sequence, these are the material facts. Or in respect of a witness, you hand up a chronology document that tells the judge, these are the material facts the witness will testify in a sequence. Judges love it. They are useful. Judges know that if they receive evidence and it is not sequenced, they can be misdirected. So we don't want that. Now, begin to prepare your first chronology document. Chronology documents are really easy to prepare. You don't need a precedent. It's the heading, the usual court heading. Call it chronology document or witness A's chronology document. It's 3 columns. First column, extreme left side, narrow column, it's meant for numbering. The middle column is the widest column, description of the event. Last column, third column, date, time, that goes in there. The oldest incident, number 1, going on to the most recent incident towards the end of the document. You have to do this, by the way, if you are dealing with an application You will have to hand up a chronology document with your short heads of argument before you go to court. It must be filed with your practice note and your short heads. That's in Gauteng. In the other divisions, opposed motions, you will get a hearing date. You have to file in advance your heads of argument. With your heads of argument, you file a chronology document, even if it's not a requirement. Judges appreciate it, okay? As long as you're in litigation, you must learn how to prepare and use chronology documents. In a trial, the document that you initially produce will become updated as the case unfolds. For example, you prepared a chronology of the documentation you received. Then your opponent discovers a series of documents that you don't have. You will then update your chronology document. I can tell you it is absolutely essential to prepare chronology documents. It's the best way for you to prepare yourself, but it guides you through the whole case, okay? And now I'm going to deal with this before we stop, because it's part of what I'm talking about. The case concept. You remember I spoke to you repeatedly today about your client's version, and that your client's version must be relevant to the dispute, must be admissible in its form, and it must be probable in relation to the facts of the case. Now, I want to show you that at the earliest stage, you must develop your case concept. You know, you'll be amazed at how many attorneys and advocates will start litigation without actually knowing this. They have an idea of what the version is, but they don't actually know what the case concept is. They don't know what client's version of what happened is. They have some detail, but not all of the detail. They have not tested it according to the relevant, admissible, probable test, and they've missed a crucial step. The case concept will inform you on each process going forward in your litigation. You develop the case concept from facts and the supporting evidence you gathered. You gathered it before you issued the summons. From this, you have to formulate a cohesive and persuasive story to convince the judge that this is a true version of what happened. This case concept will guide you through the whole thing, from your summons through pre-trial procedures to pre-trial conferences to the trial itself, all the way to final argument. Now, having obtained the facts, you have to work out your client's cause of action. It is easily one of the most difficult tasks for practitioners. You know, I told you, you listen to client, get the version down. But the lawyer's job is to take that version and plead it as a cause of action, or plead it as a plea or a defense. That's not so easy, but there is a method. Go and get my book called Practical Drafting Skills. It describes step by step how you do this. How do you take a set of facts and make a sustainable cause of action out of it? Now, here's a warning. I sounded this warning already, but I'm repeating it. Whenever you encounter a set of facts or a version that seems implausible, you don't believe it. Stop, clear it up. Never proceed in any event on the basis that, well, those are my instructions. You are heading for a confrontation with a judge who will equally find the version implausible. And let me tell you something that might seem obvious. You're a lawyer. You're a trained professional. If you find that your client's version is improbable, you can be absolutely certain a judge will agree with that. A judge will also find it implausible. Okay? So if you look at the definition of cause of action, it is a set of facts giving rise to a claim recognized by law, or it's the facts that the law recognizes as giving you a claim. Now, that tells you everything. Firstly, it's the facts. When you have the facts, you will read the law. What you do when you read the law is you're asking if I can prove those facts in court. What does the law say is my remedy? And that's your cause of action. Okay? It requires you to read the law. Now, I'll tell you, many lawyers use AMBLR as a shortcut, because if you look at AMBLR, what it does is that it's not actually a precedent. But what it does is for every cause of action, it tells you what the material facts are that you need to prove in order to obtain that remedy. And then it refers you to some cases in the footnote. Now, a good lawyer will not merely copy and paste from AMBLR. You will go and read those cases. But more importantly, you will ask yourself, can I satisfy those requirements? Remember, what AMBLR is telling you are the legal requirements. They are not the factual requirements. You have to supply the factual requirements from your set of facts or your version. Okay? And how do you deal with that? Now, I'm going to take you through this step by step tomorrow. You must be quite tired now. I'll begin with this tomorrow, and then we'll progress through the pre-trial procedures into the trial itself. Okay. All right. Have a good rest. We'll get together at 1 o'clock sharp tomorrow. Okay. Thank you.